This case was a good old family stoush about the ownership of land handed down over 350 years to the descendants of Sir John Phillips of Picton Castle. The most recent clear owner was Sir James Phillips, who had died in 1873. The current plaintiff asserted that his title was proved by certain documents which were in the possession of the other party. He didn't seek discovery of those documents, but instead went straight to the statement of claim, pleading as follows. By virtue of certain deeds, assurances, wills and documents in the possession and control of the defendants, the plaintiff is entitled to the possession of the said premises and hereditaments as such heir male. The basic function of pleadings, particularly the statement of claim, is for the claimant to set out all of the facts necessary to establish their claim, and all of the facts necessary for the defendant to know which case they must meet. A general statement that the defendant had a range of documents which would prove the plaintiff's title is far too general. Which documents exactly? And what precisely are they alleged to say? The defendant applied for the pleading to be struck out as embarrassing, and that was the question before the court. The Court of Appeal found that the claim was embarrassing. Lord Justice Cotton said, "The plaintiff must state the facts which are material for the purpose of enabling the defendant to go to trial, knowing what the issue he really has to meet is, and what is the question between him and the plaintiff, so that he may not be there taken by surprise, and the real question between the parties fall to be decided in consequence of insufficient allegations of the plaintiff. The statement of claim of necessity must set out all the facts material to prevent the defendant from being taken by surprise, because it is the first pleading, and that which ought to be referred to for the purpose of seeing whether there is a cause of action. In my opinion, this statement of claim in no way enables the defendants to know what case they have to meet at the trial of this action. This remains the test for the sufficiency of pleading to this day. Does the claim present the material facts which enable the defendant to understand the case they must meet?